Hello, this is Clark Abrams. For many years, the Cambridge Symposium has afforded me the unique opportunity to learn from colleagues around the world about investigative methods and procedures in their jurisdictions, some of which have informed and aided my work in the fight against economic crime. In this presentation, I hope to reciprocate. The Office of Special Narcotics for the City of New York is the only agency of its kind in the United States dedicated to the investigation and prosecution of narcotics and narcotics-related crimes. Bridget Brennan, the Special Narcotics Prosecutor, has implemented several innovative strategies, such as forming the Digital Forensic Services Unit and Heroin, Interdiction, and Prescription Drug Investigation Units. She also established the Money Laundering and Financial Investigations Unit, to which I am assigned. Most of the matters on which I work involve the use of international trade and the financial system to launder drug proceeds. And many of these investigations involve the use of informants who provide information to and act at the direction of law enforcement in return for consideration, usually in the form of leniency if the informant has a pending criminal case or payment. Consider an invoice for 1,000 watches worth $100 each for a total price of $100,000 US. Mr. B, the seller, issued the invoice to Ms. A, the buyer. In our first scenario, when Ms. A paid Mr. B $100,000, but Mr. B sent A only 500 watches, or 1,000 watches worth only $50 each, Mr. B defrauded Ms. A. The transfer of $100,000 from Ms. A to Mr. B represented, at least in part, the proceeds of the underlying crime, theft. In our second scenario, suppose Ms. A and Mr. B also are drug traffickers, and Ms. A received drugs on consignment from Mr. B. Ms. A sold the drugs, generating criminal proceeds, and needed to pay Mr. B out of those proceeds. Mr. B issued Ms. A that same invoice for 1,000 watches at $100 each, but sent Ms. A watches worth $20 each. When Ms. A sent Mr. B a wire or check for $100,000, it appeared to everyone, including Ms. A's and Mr. B's banks, that the entire payment was for watches, when in fact, $20,000 was for payment for watches, and the bulk of the transfer, $80,000, was for drugs. Through use of the technique of over-invoicing, a false invoice, Ms. A and Mr. B have taken advantage of international trade and the banking system to disguise and conceal the $80,000 transfer for the purchase of drugs. Here, because the $80,000 transfer represented proceeds of crime, the proceeds of the drug sales, the transfer constituted money laundering, in a scheme commonly referred to as trade-based money laundering. In the third scenario, suppose our watch merchant was located in Colombia, where the currency is the peso, and imported watches from a manufacturer located in the US who required payment in US dollars. However, the merchant's government, as many governments do, restricts the merchant's access to foreign currency and foreign bank accounts, requiring the merchant to obtain US dollars through the central bank, an expensive and time-consuming process. In addition, consider a drug trafficking organization based in Colombia, whose drugs were smuggled into and sold in the United States. The proceeds from the sale of the drugs were in US dollars, cash located in the United States, but the drug trafficking organization demanded payment in pesos. A money broker, commonly referred to as a peso broker, sees an opportunity. This individual brokers an arrangement in which the merchant pays pesos to the drug trafficking organization in return for the drug trafficking organization's US dollars. The drug trafficking organization is willing to sell the US dollars to the merchant at a price lower than what the merchant would pay the central bank. The peso broker, or more likely the broker's agent or worker located in the United States, collects the US dollars, deposits them into bank accounts, often set up in the names of shell companies, and sends payment by wire or check in US dollars to the merchant supplier. The exporter, that watch manufacturer, who once paid, ships the watches. The merchant importer gives pesos to the peso broker, who, after taking a commission, gives the pesos to the drug trafficking organization. The drug proceeds have been laundered through a parallel banking system. This is a form of trade-based money laundering, commonly referred to as a black market peso exchange or parallel market currency exchange. Many of the drug and money laundering investigations I work on utilize confidential informants, the peso brokers who work with law enforcement. Typically, we are on the money side of this diagram and deal with counterparties on the drug side. When we work with informants who have infiltrated high-level drug trafficking and money laundering organizations, we want to avoid disclosing the identity of our informant for as long as possible. There are many reasons for this, one of which is the desire to utilize the informant in multiple ongoing investigations. Consequently, we aim to use the informant not as a trial witness, but rather for intelligence purposes, to provide information that law enforcement can use to obtain admissible evidence against the individuals and organizations we are investigating, without referring to and involving the informant. Let us see these principles applied to one of my investigations and prosecutions. Our informant received a contract from a drug trafficking organization in Colombia to launder $500,000 in drug proceeds located here in New York City. Our informant provided the drug trafficking organization with a phone number for the informant's worker agent in New York City. In fact, this worker agent was an undercover officer. An individual from the drug side contacted the undercover officer to transfer the $500,000. When they met, the individual, whom we will call Mr. C, transferred $200,000 to the undercover officer. Mr. C stated that he would collect the remaining $300,000 within 48 hours, then contact the undercover. Officers on the undercover's team who were nearby followed Mr. C back to the apartment building and identified the apartment in which he resided. Over the next 48 hours, the law enforcement team conducted surveillance on Mr. C and observed him leave his apartment building empty-handed and return with a very heavy-weighted bag. Based on what occurred, we had probable cause to believe that Mr. C had $300,000 of drug proceeds and maintained records of money laundering transactions in his apartment. We applied to the court for a search warrant, and our application was granted. We expected to find and seize drug proceeds and records, ledgers, of drug money laundering transactions. In that case, most likely, we would have deferred prosecution of Mr. C for money laundering because we were in the middle of the investigation developing evidence against additional and higher level individuals, and we're not ready to take down and conclude our investigation. However, what do we do if, as in this case, we also find drugs or guns in Mr. C's apartment? Although money laundering is a serious crime, an individual in possession of a large amount of drugs or guns is a significant and immediate threat to public safety. We cannot defer. We must arrest and prosecute immediately. We recovered drugs, guns, $300,000, and records in Mr. C's apartment. That is sufficient evidence to convict Mr. C at trial without having to disclose the identity of our informant. Not so fast, though. Before trial, the court will conduct a hearing to determine the legality of the arrest of Mr. C. That is, did law enforcement violate Mr. C's constitutional rights? Here, the legal basis, the probable cause for the search of Mr. C's apartment, which led to the seizure of the drugs and guns, came from the undercover officer's encounter with Mr. C. And the undercover officer is the agent of our informant. Therefore, if the undercover officer's identity were disclosed to Mr. C and the drug organization, then our informant's existence and identity would be exposed. That would compromise current investigations and eliminate use of the informant in future investigations. As you can see from the headlines in this slide, it also could be risky to the informant and his family. What do we do? Can we prove the legality of the arrest of Mr. C without compromising our informant? On a showing of extreme exigent circumstances, the courts of the state of New York allow us to bring the informant or the undercover officer to court to be examined by the judge in a closed courtroom outside the presence of the defendant, Mr. C, and his attorney, what is referred to as an in-camera proceeding. The judge protects Mr. C's constitutional rights by making an independent determination of whether the informant or the undercover officer is credible, that is, telling the truth, and whether there was probable cause to justify the search and arrest. If the judge makes those findings, Then the judge seals the record of this examination, meaning the record remains non-public. Now, we can proceed to trial and present our evidence against Mr. C without testimony from or any reference to our informant. In conclusion, the procedure available to us in New York allows us to pursue a prosecution while ensuring that our informant remains a confidential informant. Thank you, and I look forward to meeting and seeing many of you in person next year at Cambridge.